In this video, I'm going to reveal the 4 hidden settlement traps that destroy more legal cases than you'd ever imagine. If you're facing any kind of legal dispute right now, one of these traps could be costing you thousands or even hundreds of thousands of dollars without you even knowing it. I'm Santiago Cueto, board-certified international business law expert and best-selling author. In my nearly 30 years of practice, I've seen brilliant attorneys and savvy business owners fall into these exact same traps over and over again. But here's the thing. Once you know what to look for, these traps become completely avoidable. So stick around, because by the end of this video, you'll know exactly how to spot these settlement landmines before they explode your case. And I promise you, trap number 3 is going to shock you. It's the one that even experienced lawyers miss 90% of the time. But before we dive in, let me ask you this. Have you ever wondered why some people walk away from settlements feeling like they won the lottery, while others like they just got robbed in broad daylight? The difference isn't luck, it's knowledge. And that knowledge starts with avoiding these 4 critical mistakes. Here's trap 1, the quick settlement mirage. This is where the other side comes to you early in the dispute with what seems like a reasonable offer. They say things like, "Let's just put this behind us," or "We want to avoid the cost of litigation." It sounds reasonable, right? Well, it's wrong. Here's what's really happening. They're betting you don't even know the true value of your case yet. Think about it. If you're eager to settle quickly, what does that tell you about the strength of their position? I had a client who was offered $50,000 to settle a contract dispute within the first week. It felt like easy money. But when we dug deeper, we discovered the other party had already cost my client over $200,000 in lost business. That quick $50,000 settlement would have been highway robbery if he'd accepted it. The antidote? Never accept the first offer, no matter how attractive it seems. Always investigate the full scope of your damages first. Remember, they wouldn't be offering to settle if they thought they could win easily. Here's trap number 2. The all-or-nothing mentality. This trap catches people who think settlement is a sign of weakness. They say things like, "I'm not settling for a penny less than what I deserve," or "It's the principle of the matter." Look, I get it. When someone wrongs you, every fiber of your being wants justice. But here's the brutal truth about litigation. Even if you're 100% right, you might still lose. Juries are unpredictable. Judges have bad days. Evidence gets excluded on technicalities. I've seen clients turn down 6-figure settlements because they wanted 7 figures, only to lose at trial and walk away with nothing, except a massive legal bill. The smart play? Always evaluate settlements based on risk-adjusted value. Ask yourself, what's the probability of winning at trial? What are the costs of getting there? And what could go wrong? A guaranteed settlement of $200,000 might be worth more than 60% chance of winning $400,000 at trial, especially when you factor in legal fees and the time value of money. Now, if you're finding this valuable so far, do me a favor and hit that like button. It really helps the algorithm show this content to other people who need to hear it. And trust me, you're going to want to share trap number 3 with anyone you know who's dealing with a legal issue. And here's trap number 3, the future claims blind spot. This is the trap that even the most experienced lawyers miss 90% of the time. Here's what happens. You settle your current dispute, sign the agreement, cash the check, and you think you're done. But buried in that settlement agreement is language that releases not just current claims, but all future claims related to the dispute. 6 months later, you discover new damages. Maybe you find out the other party was hiding assets. Maybe the breach caused problems you didn't know about yet. But guess what? You can't do anything about it because you already released those claims in your settlement agreement. I had a client once who settled a partnership dispute for $100,000. It seemed fair at the time, but 8 months later, we discovered the partner had been embezzling money through a shell company we didn't know existed. Another $300,000 in theft. The settlement agreement had such broad release language that we couldn't touch that money. The solution? Always limit releases to known claims as of the date of settlement. Add language that specifically excludes fraud or intentional misconduct that hasn't been discovered yet. Your future self will thank you. And here's trap number 4, the tax consequences surprise. This might be the most expensive trap of all because it hits you twice. First in the settlement, then again at tax time. Different types of settlements are taxed differently. Punitive damages, usually taxable. Lost profits, definitely taxable. Personal injury, often not taxable. But here's where it gets tricky. How you structure and document the settlement determines how the IRS treats it. I've seen people negotiate a $500,000 settlement only to discover they owe $150,000 in taxes that they never budgeted for. The fix is simple, but it's critical. Always consult with a tax professional before finalizing any settlement structure. Sometimes you can negotiate the same economic outcome in a more tax-efficient way. Other times you need to increase the gross settlement to account for the tax obligations. These 4 traps have cost people millions of dollars in settlements that should have been wins. But now you know what to watch out for. If you found this valuable, smash that like button and subscribe to my channel for more insider legal strategies that can save you time, money, and headaches. And remember, in legal disputes, knowledge isn't just power, it's profit.